Beh, vi prego di accomodarvi, cominciamo la seconda sessione, il secondo panel, che è moderato da Domenico Gullo, del comitato esecutivo dell'Associazione Antitrust Italiana, e i panelist sono Katrin Schallenberg, eh, di Clifford Chance, Parigi e Bruxelles, che nonostante sia austriaca rappresenta l'associazione francese degli avvocati praticanti le droit de la concurrence. eh, Ilaria, Ilaria De Lisa, di Gleis Lutz, che rappresenta lo Studienberufungskartellrecht tedesco.
Forse in inglese così.
Eh?
Forse in inglese così seguono.
Non si sente?
No, forse in inglese però.
Ah, ok, ma io sto parlando con lui.
Ah no, perché
Oh, ok.
no, capisco.
Me.
No, capisco.
Okay. I thought you knew each other. Well, good. So let's start the second panel then, which is coordinated by Domenico Gullo of the Executive Committee of the Italian Antitrust Association, and a panel which is composed of practitioners representing the associations of France, Germany, the Netherlands, Spain, and Italy. And we have as panelists Catherine Schallenberg, which represent the French Association Avocats Pratiquants des droits de la concurrence en France, Ilaria Delise, che rappresenta lo Studienberufungskartellrecht, famosissima associazione tedesca, di Andrea Cicara, which represent the Italian Antitrust Association, Maurice Schaufeli, which represent the Dutch Association of Antitrust Lawyers, and Pablo Solano Diaz, who represent the Associación Española para la Defensa de la Competencia. We have about 1 hour, 15 minutes.
Okay.
Domenico, please have the floor.
Thank you, Alberto. First of all, welcome to this second panel, and thank you to all the speakers, representatives of different jurisdictions. We will offer us the perspective from the point of view of practitioners. I think that after the views of the representative of the authorities, it is very useful to take a practical approach and see in concrete terms the difficulties faced by advisors and practitioners in relation to the below threshold merger control. I think that a number of points relevant in our perspective, I mean the practitioner perspective, has been raised in the first panel. In particular, I think that legal certainty and also the need to have to take the right decision with the client. For example, if it's better to involve the competition authority in case of below threshold mergers, or if is probably better to take the risk waiting for the terms that the competition authorities has to call to exercise the call-in. In any event, the local nexus as well. I think that a lot of things already we heard in the first panel, and probably the best way. I drafted a lot of things, but Alberto and Matteo already said. So I think that the best way is to add, and we follow the same order. So Ilaria will be the first, and after probably Pablo will talk.
Okay. Can you hear me? Yes. Well, first of all, thank you very much for the invite, also on behalf of the Studienvereinigung Kartellrecht from Germany. And what I wanted to do with you today, if you could please please, the presentation. I have a couple of slides to show you the German approach. Now, we've heard about it before, also from the perspective of the authority, but what is the German approach to below the threshold mergers? Now, some of you already probably know it. It's about the transaction value threshold. This is the norm, and I will just focus on the last 2 points because those are the most important one for us as practitioners. But before we start, just a general couple of points. First of all, Germany has an ex-ante review and does not have call-in rights as of now. The transaction value threshold was introduced as a subsidiary criteria in 2017, and the idea behind it was the Facebook WhatsApp situation. And the goal was quite clear from the beginning. They wanted to cover cases where the target has a low turnover but is competitively relevant. It has competitive positioning. And this, however, it would not be caught by the normal turnover threshold because it's too low, this threshold at that point. The topic is not sector specific, so it has covered different points. It has been drafted having in mind the digital and the pharma biotech sector. However, it has brought in about 140 cases in a variety of topics, including those two as well as real estate. This meets about 3% of cases per year at the German authority, the Bundeskartellamt. I would then use this opportunity to go a little bit more detail about the topic. Now, the part that you probably all know best is the 400 million euro value of the consideration, so the quantitative threshold. Now, because it is a quantitative threshold, it provides a good solid basis. And what also helps in providing a solid basis are the guidelines from the authority. The German authority provided them together with the Austrian one, and they are quite helpful in determining whether the 400 million turnover, 400 million threshold is reached, yes or no. So in practice, for us as lawyers, it's generally not too complex in most cases to determine if those 400 million are reached or not. However, going forward, there are a couple of things to keep in mind. The first one is it has been raised the possibility of lowering this amount from 400 to 300 million. Now, this is interesting because usually thresholds are increased by the authorities, whereas in this case, it would show an opposite direction. So this is quite interesting per se. And the consequence of it would, of course, be a possible increase in the number of cases. And as we've heard before from Professor Oste, the German authority already reviews 900 cases per year. So this would actually increase bureaucracy and possible the impact on companies and the authority as well. So this is the quantitative part of the norm, and this is quite straightforward, as we said. Straightforward, however, it's not the second criteria, which is more related to the local nexus. And as we heard in the first part, in the first panel, already the local nexus was quite central there as well. The norm requires that the target, so it's only about the target, has substantial operations in Germany. And as you can tell already at this point, we're talking about a qualitative criteria. So therefore, just per se, even more complicated to handle than quantitative ones. Here there is somehow a connection to the local nexus, but it's not the pure German local nexus, which requires domestic effects of the concentration. But as I said, it focuses on the activity of the target, and the activity must be current. What is interesting here is that it has been suggested to expand this, so to bring it beyond the current situation and look at potential or future cases. Of course, this brings up a question of legal certainty, and it brings up the question of which criteria would then be relevant, because which kind of documents would you need, which kind of level of proof, also which time frame would be relevant to examine this potential or future activities. Again, also, we would have, like in the slide before, for the value threshold, we would have a possible increase of cases. And of course, something like that would need to be very carefully balanced, also with the bureaucratic impact and the rights of companies. But then you might ask yourself, why do we even need this? Because, I mean, the norm is already quite clear. Why expanding it towards the future or potential activities? And the reason you have it here, I have listed 2 cases, quite recent, in which the authority would have liked to analyze materially a case and could not because the targets did not have substantial legal operations in Germany at the relevant time. And as you can see here from the cases, one involves Microsoft and OpenAI, the provider of ChatGPT. And at the relevant time, ChatGPT was not relevant enough in Germany. But we all know that that situation possibly could be considered different if we look at it from the present perspective. Same thing is for Microsoft Inflection AI. Now, maybe some of you have heard the case because it was debated also in other jurisdictions. And here we're talking about an equi-hire. So an also very interesting case for an authority possibly to look at. And in this case, the authority could not look at it materially because there was no substantial operations in Germany on part of Inflection AI at that moment. So the question then becomes, as practitioners, when our clients ask us, okay, what are the relevant criteria to determine if there are substantial operations? Well, that's a good question. And it's not an easy question because we have guidelines from the authorities and they provide some examples. We have a little bit of case law, not too much, both from the authority and the courts. However, this is also not yet settled. So we still have uncertainty, and very often judgment calls need to be made, understanding whether substantial operations are present or not. What is important here also to know is that the standard is industry and market specific to the point where actually you need to analyze case by case what the target is doing actually. And you have both turnover and non-turnover related criteria. Some of them more or less suitable to the point. But I want to draw your attention to the last point because this is the one that might be more significant from a practitioner's perspective. Namely, as Professor also said before, this point right here that I'm going to read for you. There is no significant domestic activity if the target, so again, just the target, generated a turnover below the second threshold, and this turnover adequately reflects its market position and competitive potential. In those cases, the transaction value threshold does not apply and notification is not required. This means that even if the transaction value is above 400 million turnover, even if the other criteria that are required by the law are fulfilled, if you can prove that the turnover adequately reflects and it's low, then you might be outside of this norm. This is, of course, very impactful, but it's also not necessarily a very easy workable criteria because you have to think about what is a more mature market? How would it be in a newer market? What if the market were growing? What if it were more innovative? What if AI came into play? And on those points, we do not have clarity. So it is interesting, but we're going to have to see where the dust settles. But this last point that I just showed to you about the more mature markets, this has been very recently very relevant for the community in Germany because the court, the OLG Düsseldorf, which is the higher regional court for Düsseldorf, which is the court that is responsible for the appeals of the decision of the Bundeskartellamt, they had an Adobe case recently, 2025. And there the idea was, does the turnover of the target adequately reflect its market position? Because again, if the answer is no, turnover, the value threshold would not apply. And here the court analyzed the case and argued, okay, the software was offered for a fee since 2009. What does this mean? It means that it has been offered as a product for years in a paid relationship. So it was monetized for a longer time. For this reason, the conclusion of the court was that the Bundeskartellamt should not have initiated a dissolution procedure in this case. Now, this is interesting and it shows that somehow turnover can also act as a primary indicator in more mature markets. But again, the workability is still a question mark. There is another case that I wanted to cite to you, actually the second case that was decided by the courts on this topic, and it's the meta customers. Also here, the court adopted a more restrictive approach compared to the Bundeskartellamt and ruled in favor of the parties. Now, meta customers, some of you may know of it because it was also discussed by the Commission. And here, the courts focused on the topic of whether the target activity was substantial enough in Germany at the relevant time. The court and the parties focus on the target's few German customers, as in contractual relationship customers. The place basically where the use of the services of the target is decided, their own clients. But those were just few in Germany, and the Bundeskartellamt added a layer in its first decision and looked after that. It looked at the clients of the target. And those were millions of German end customers. And by doing that, of course, because the customer was the data processor for this data, they somehow were able to say that there was substantial local activity. Now, the court rejected this and said that the Bundeskartellamt wrongly requested the parties to notify, but it's going to be interesting to see how this is handled because the case is currently pending in front of the Federal Court of Justice for Germany, and it should be decided very soon. So we're all eagerly awaiting to see what the result is going to be. And why are we also eagerly awaiting to see how it is? Because as you can see in the last point that I mentioned in the central line, very recently, Andreas Mund, the president of the Bundeskartellamt, has looked at the cases, and especially, I suppose, at least discussed the Adobe, and said that he's not so sure today that the threshold is the best solution based on what the courts have made of it. And he even mentioned that calling system sometimes might be a better way forward. And this is the case, even though a few months ago he was rather against it. So I don't know if he was speaking personally or on behalf of the authority, but it's interesting to see this kind of change because, of course, the courts have ruled in favor of the parties on this. I would then come to the last slide, and as everybody here already mentioned, legal certainty should apply also to below the threshold mergers. Now, from a German perspective as of now, I still find that the German system is rather reliable. We have an ex ante review, we have no call-in rights, and the system is anchored in a clear quantitative criteria. Where the problem starts is again, as it is we've seen before, in the more qualitative criteria, namely the substantial local activities. Now, going forward is, of course, hopeful that those new qualitative criteria or extensive interpretation will be very clearly balanced and will take very much into consideration the bureaucratic impact and the rights of companies. Also because, as we see in the last point, tools, maybe the threshold or other system might be integrated in the future. So I think the takeaway here is the German system has a solid base, and we just can hope that going forward, legal certainty and predictability, which are so essential for us and our clients, will be further valued. Thank you very much.
Thank you very much, Ilaria. Very interesting indeed. I personally, I think that also in Germany there are a lot of open issues, and I personally believe that the quantitative criteria is quite better than the qualitative ones. I also thought that in the past, in the Italian legislation, the thresholds were not cumulative like now, and they were alternative. So probably could be also this a solution to have more legal certainty. In any event, Pablo, what about Spain?
Hello. Hello. Can you please upload the presentation? Well, thank you very much. Okay. Do I need to push any? Okay. Okay. Thank you very much. Well, first of all, thank you very much for hosting us here in this amazing environment. It couldn't be said enough. Well, what I wanted to say is I wanted to return the favor of the regulators who were very objective. And I also want to be very objective from more of an academic point of view, if you want. However, I wanted to present the vision on the Spanish market share based thresholds from a slightly different perspective. So I think it could be a useful tool to tackle the challenges that we're facing now in merger control. I agree with Michela about that. However, I also think we need to reflect on the downsides to it. So Michela referred to the fact that it might be under-inclusive sometimes. I think it might also be over-inclusive in some ways. So let me well, I don't think the actual market share thresholds require any refreshment because we just discussed those. 30% market share in Spain or a geographic market defined in Spain, or 50% market share if the target has less than 10 million euros turnover in Spain. But then that's the theory, okay? That sounds easy. But if we delve a little bit more into the detail, then we face challenges. So the first challenge that we face is how do we attribute how do we allocate the market share? So for instance, if we have smaller markets, if we have sorry, on the contrary, if we have geographically broader markets than in Spain. How do we redefine those markets? It might not make sense by using the economic principles that we use under the Commission's notice. So that is already a source of uncertainty. The second area of uncertainty might be what about the in case of a joint venture, for instance, what about the market share of those companies of the joint venture that are unrelated, completely unrelated to the transaction? In those cases, there might be a problem with the causal link to the transaction. And I brought about a couple of cases related to the typical examples, right? So one case would be the case of an investment fund that is buying out companies in different sectors. So this company happened to have other companies in the same sector as the joint venture it was entering into, and those market shares were considered relevant for the purposes of even notifying a transaction that would not be notified otherwise. So that's already another source of uncertainty. It is true that the Spanish Competition Authority hasn't gone as far as to consider market shares in those of those subsidiaries over which the parent to the joint venture doesn't have control, but just a minority shareholding. But that's obvious, right? And we have this, for instance, this case, which is a case related to a company that operates. I mean, they develop greenfield generation plants, turnkey projects. So the Commission only and this is very relevant for local markets, right? Because if you have plants in different local markets, depending on the type of control that this company has over those facilities, if it's especially if the business is turnkey, meaning that they develop the projects and they they sell out the projects, depending on whether they keep control for some time, because there is also the stability element, those plans will count towards the notification threshold. So that's another source of artificiality, let's say. And then there is a lack of clarity. Which market share do we consider? Because usually, I mean, for the accounts, for the turnover thresholds, those are the last accounts. So that's quite straightforward, right? But for the market shares, do we consider the last available data from last year, future data? And I brought about a case, which is this Iberdrola case, where a company that is obviously Iberdrola is one of the big energy companies in Spain that is also present in generation, bought a plant that was a greenfield plant that wasn't operating in the market yet. So it had prospective market share, but since Iberdrola already exceeded the market share, and like Michela rightly said before, the test is whether a 30% market share is acquired or increased. This means that for low that the greenfield plant's market share would be, it would increase the parent company's market share. So even future market shares could bring a transaction under the remit of merger control. This is nothing new. There is, of course, for instance, comes to mind the Novartis GlaxoSmithKline case of the Commission, where patents that were still, medicines that were still in third phase trials were considered for the purposes of a transaction. But that gives you more certainty because we're talking about projections of future turnover, which is always something that also talks about the rate of success or the expected success of the business you're developing. In this case, it doesn't matter that the greenfield plant that you're acquiring doesn't have any prospects of success, because since they're entering into the markets, then they will have some market share and they will meet the thresholds. Other challenges. So I brought about a couple of examples where the structure of the market doesn't really change because of the transaction. So, for instance, we have this case where a beer manufacturer that you might know, San Miguel, now Mao, acquired a local distributor, and pretty much all the market share that was relevant for the transaction that the distributor brought to the transaction was related to San Miguel's products. So the contractual arrangement was, the change from a contractual arrangement to a structural arrangement did not really change the market share picture in the market, right? But it needed to be notified. For instance, where artificial market definitions, for instance, the call termination. Every time you call with your cell phone to another cell phone that is operated by a different telecom operator, that telecom operator is providing a wholesale service to the first operator, which is call termination. They need to allow your company to call them, right? So they have a 100% market share in that market, regardless of how small the turnover is. That means automatic notification of all transactions affecting the telecom sector. And then the joint venture example again, imagine a situation where you have a situation of joint control that turns into sole control, but the market share is still the same because it is the joint venture's market share. That was the case of these SELO transitions in the case of glasses, of sunglasses. So what is the commission, the Spanish competition authority stance on this? During the hype about the Article 22 notice of the commission, at the beginning they were kind of, I mean, formally, they were kind of skeptical about the possibility of using that channel. I mean, referring transactions that were not notifiable under the Spanish thresholds. But they did refer one, which is this Qualcomm Autotalks transaction. Fortunately or unfortunately, it was withdrawn. So we're not in a NVIDIA run AA situation here, unfortunately, from the intellectual point of view, right? And then what they do in practice, so that's, let's consider the avenue already closed for the moment, right, after Illumina. And what they do, what we're seeing from a practitioner's point of view that they're doing now is that using the gun jumping mechanism based on the market share, quite flexible market share threshold that they have to investigate into transactions that might be problematic, even if they're not fully notifiable in an orthodox sense, right? And we saw an increase in the number of gun jumping investigations in the last 2 years, 9 in between 2022 and 2024, fines amounting to 2 million euros. And this is a good avenue for the commission to actually force, because as Michela mentioned before, the commission can also impose remedies. So this is also a good way for the commission to exercise calling powers without really having calling powers, because you can then subject the transaction to remedies, right? Then gun jumping, in principle, in Spain, what the approach that the commission has taken is they play with the liability. So if you're diligent enough, you might not be liable, you might not suffer fines, but you still have to notify. So this mechanism that I equated to calling that allows the commission to investigate into the transaction and eventually subject it to commitments is already activated, regardless of whether you were negligent or not. Some cases in which authorities, well, the Spanish authority considered that companies were negligent. So, for instance, cases where there was reasonable doubt. For instance, in this Grifols case, they had, I think, a 49%. Well, the 50% threshold applied, and they had 49% market share in terms of volume and 51% market share in terms of turnover. That's probably a case of reasonable doubt. So they were probably not so diligent in not notifying that, right? So clear precedents. This clear precedent here, the Xpera case, this is about the call termination. So if you know that there is a doctrine that every telecom merger has to be notified because of this call termination markets, not notifying it is obviously being negligent, right? And what are the precautions? Well, fortunately, there's consultation and there's ad cautelam notification. So in case of doubt, what is usually recommended is that you engage in informal pre-notification contacts. And to be honest, my experience is that the commission is quite open to saying, look, I don't think this is notifiable. So they're quite honest in my experience. And then a last word, since I have a couple of minutes more on the application of antitrust rules to non-notifiable mergers. That was discussed to some extent in the previous panel, so I won't dwell on this. But I really think this could be an alternative. I really think this could be a possibility for authorities to put their minds at rest while not really using merger control to capture transactions that were not devised to be captured by merger control rules. Why? Because it has been said here, I don't remember who, sorry, that merger control is the field of legal certainty. So you cannot twist merger control rules to capture transactions that are not certainly notifiable, but you can definitely use antitrust rules to ex post capture transactions that might also pose antitrust problems. Sorry, just one thing just one point to finish off that was discussed before, and I find really interesting. I think the problem or the beauty of Towercast is that it was applied to a transaction as is. So does the transaction amount to an abuse of dominance itself? That's the tricky question. And this reminds me of all the case law on Article 106, about especially this Greek case, the DEA case, where the fact that special rights were conferred was considered already to be an abuse of dominance. So that's one question. That's a tricky question. But there is a much more simple question, which is if you do something else aside from the transaction, and if you do a string of transactions, the overall strategy of which is a deviation from competition on the merits, then Article 102 of course applies. Of course applies. And again, that's not the Towercast case. That is probably a simpler case than the Towercast case. And I don't recall any merger control case, but in agreements there are several cases. For instance, the generics or the Servier case, where the network of agreements that might have been an illegal agreement in the form of a pay for delay arrangement could also qualify as an abuse of dominance because there was an additional element on top of it. And then there is this interesting decision by the French Competition Authority about slaughterhouses, where they applied the Towercast doctrine to agreements, and they considered that a network or a string of transactions that ended up in a market share reallocation, restructuring of the market by means of below radar transactions, that could amount to an agreement. Of course it could, because we're not saying the transaction itself. This is not the Philip Morris case law, which is the equivalent to the Towercast case law, and it would probably only apply to minority shareholdings, right? Because once you are no longer independent, there is no anti-competitive agreement. That's clear. But if you do several things in the form of transactions that end up being an anti-competitive agreement, that can also be prosecuted on its own rights. And that's all. Thank you.
Thank you. Thank you very much, Pablo. Well, if probably what we can say is that the adoption of below threshold merger control has increased the discretion and the powers of the antitrust authorities. This is matter of fact. So probably, Andrea, you can say something regarding Italy.
Yes, I was thinking that after Alberto and after Theo and after the commissioner and after you, Domenico, arriving, adding something for Italy, it's
I'm sure
we,
that
we will
you'll
try.
be able.
We'll try to do. If I have the
Yes. Sorry.
yes, okay. So I will start stating something that's been stated and restated. That possibly when there is a differentiation between the way the Commission conceived the moment in which they were pushing for a referral and for a Collina, which were the objective at the time. That was essentially to intercept that kind of a transaction that were escaping ordinary objective threshold. Therefore, the push to try to get this killer acquisition for small companies yet to enter, about to enter, will reduce turnover if already enter into the market. And so the way I would say in general, the national authorities have construed this Collins power. And this is the same approach of the Italian authority. The Italian authority has construed, interpret these new power, these tools, as a way to regain jurisdiction overall, 360-degree with respect to a number of transactions of feeling they were escaping the due review. And we know that there is no focus on innovation in the Italian practice. 80% of the cases are traditional transactions. The law provide this possibility is wide, there is no restriction, and the authority in its practice has implemented this way. So the point is which kind of system we have in Italy, and is a system which provide sufficient degree of predictability, and if there is a gap in predictability, shall we intervene where? In the thresholds, in the criteria, in the procedures, pre-closing, post-closing, can we do something? And in this very short intervention, a lot has been said. I will try to focus on this. So the first point is that the Italian system is a system that provides wide discretion to the authority, a very general possibility of intervention. And this is provide on its own has an element of lack of predictability, or someone should say any kind of transaction may be caught if there are a number of elements. This is important because the Italian authority used this to review the case 360-degree, but introduce elements that my views, I would say, I'm speaking as practitioner without involving the association, or also for the association, has some issues because a key element in orienting the practice and the use of calling powers by the authority are not a priority identified upfront, are not economic sector identified by the Commission, but a due weight is given to whistleblower. A due weight has been given to competitors. We have 5 cases out of the practice of the authority activated by 4 whistleblower, 1 a competitor. And it is clear that this on its own an element that trigger lack of predictability and concern, because we know that when in this transaction, I mean, that they end up, I think, in all cases, have been cleared in phase 1. And we heard that there was a wide difference between the market share and the impact of competition represented by the whistleblower and what the competition authority, the ICA, found it out. So this is an element that generate concern, and this is a reading and implementation of the authority that generate concern. Wide discretion, criteria, I don't want to say loose, but pretty wide, relevance to the role of whistleblower. So I think that this is an element. But then if this is a situation that we have a general lack of predictability, it is possible to think to some limit. It is possible to think a way this system that is implemented that provide new power to authority can be improved, or can be in a discussion with the business stakeholder and with the authority, can still enable the authority to review the transaction that it wants to review, but provide a sufficient degree of certainty to the company. And we think it is possible to reactivate a debate on this. And essentially, the first part is that focus on how to identify the targeted transaction. So today we have very broad threshold, very broad criteria. One of the 2 mandatory threshold for the review or 5 billion. We don't have local nexus. We don't have any indication relating to value of the transaction. We don't have, as we say, any elements which may imply a reference of significant presence or impact in the domestic market. Possibly a discussion how to review or to which extent this threshold might be reviewed would be opportune, because this generates an absolute gray area for the players and for those that has to advise the player. It would be also opportune for the authority let's say, to be brave, to indicate which are the area of enforcement, the area of priority, where they want most to exercise this calling power, and to provide to the party a sort of a reference guide in terms of the sector. This might be also an element that is or might be considered and should be opportune for the authority to address this debate. So what might be suggested is for the authority to activate this debate, to start this internal confrontation or discussion, and try to deviate from such generic approach. But the generic approach determines lack of predictability, that is legal uncertainty. It's not only the lack of clear criteria to identify what is the target of a calling power that generate this situation. Procedures is very relevant. We have a situation in Italy where it is true the parties can go for a voluntary communication to the authority, and they can present elements and facts and ask the authority to express whether there is a need of notification or not. This is a situation that it is possible. But first, we may end up in providing a lot of information to the authority. But second, most importantly, the authority has 60 days to revert. 60 days to revert to the party. 60 days to revert in a pre-notification situation. That means that in case I get confirmation, I have to notify, then I have to start the process. In a transactional world is a biblical period of time. It's enormous period of time with enormous cost for the party because the delay on the transaction usually is on buyer. And the seller will ask breakup fee indemnization, increase of price, and this really is a relevant issue. So as regard to the pre-closing, the authority should concern to have other references. In the UK, CMA provide for a submission that can be less than 5 pages and commit to revert in 1 week. 1 week from the moment in which they receive last set of information from the party. 1 week with respect to 60 days, I think is a gap that somehow can be balanced and compensated. And the other point is post-closing. The post-closing is, we know, a quite unbalanced situation from 60 days to 2 years. But what is important for post-closing is to say that post-closing review should be admissible and compatible with a system where criteria to identify targeted transactions are clear and the areas of priority are clear. If these are not clear, we should not have this area of the post-closing. If we have clear criteria, then we may consider post-closing, but the post-closing review cannot be that extended because the post-closing review also has a cost and we should be on much more reduced time than 6 months. So we think that it is not in the interest for the business, but for the regulators not to provide clear reference for criteria to use this power. That is not in the interest of the regulator, does not identify the area of intervention. That is not in the interest of the parties and of regulators not to set more reduced time to revert about pre-notification. And what concern also the post-closing situation. All this create uncertainty, may affect the same objective of the innovation, but what we want to say, it has a cost. Cost of compliance. We have to check, monitor. Risk of litigation with the authority, with the private party. Planning difficulties. It is very difficult in this situation of uncertainty to plan a rollout on activities or expansion of business. Transaction costs. Of course, I will have economic advisor, lawyers, and this increase the cost. Risk of cost. If I have to bear the risk of the transaction, normally buyer has to indicate which are the regulatory requirements, which are the jurisdiction where they have to file. And they take the risk for the rest. And if I have risk of call-in, I have to protect. How can protect? I should go for an insurance coverage. Possibly this means money. Or I should negotiate or accept a breakup fee clause that is also cost. So this is something we have to take into account. A system that is too strict limit growth. I give you 3 figures. The cost of legal uncertainty, the cost of lack of predictability is estimated between 1 to 3% of the total annual turnover of a company, from 5 to 10% of a cost of a transaction, from 10 will represent to 10 to 20% in terms of percentage on litigation. That's what stems from the legal uncertainty. So I think that any regulator should consider, of course, pursue of its own objective of enforceability and fill the gap they have to fill. But there is also, and we know what report of Mr. Draghi say about, they need to be really attentive to avoid to overload with overlayer of regulation or uncertainty the company and the economy at EU level. And so I think that I would really advocate for the authority to consider this element when adopting new regulation, as maybe in France, or when reviewing its own regulation, as maybe in Italy.
Thank you very much, Andrea. Applause. So we all agree that the delay in the completion of the transaction and the increase of the costs are two main issues that we have to consider, of course, for the clients, for the companies, also for all the main aspects relevant. Catherine.
Yes, thank you. I feel like we're not making enough disclaimers on this panel, so I'll make a few before you ask yourself how someone with my name and my accent can represent France. I am Austrian, but I have been practicing in France for 20 years. And then my other disclaimer is that I'm not speaking on behalf of the French Association and also not on behalf of my firm. And I keep it brief because I see you're nervously passing on papers, and I don't have slides either. So I wanted to just address three things. One was, what's the actual purpose of below threshold call-in powers? The second one was I was going to share a few observations on the French proposal. And then my last point was around the impact that those tools could have on innovation. So maybe starting with the first, and I find it, I have to say, a bit disconcerting that we no longer ask ourselves what's the actual purpose of having call-in powers. And when I hear this debate, I'm not sure that that's so clear for the national authorities. But from a business perspective, I would have, or we would have welcomed, I think, some economic evidence or some studies that demonstrate that there is an actual need for call-in powers. So either, and we've talked about acquisition. So either this is to intervene in cases where there is technology or some know-how that has the potential to become a competitive threat, but has no current revenue and therefore cannot be captured by any meaningful threshold. If that's the purpose of a call-in tool, then I think that should be clearly stated. And again, there should be some effort at least to see if there is actual evidence. And I think if we look and it's not an easy exercise, but if we look back at the 4 years of Article 22 enforcement under the new old regime, only 4 cases actually were referred to the European Commission that were true under the threshold cases. One was Illumina Grail with the outcome that we all know. The other one was two were abandoned. One was Qualcomm Autotalks, which you mentioned. Interestingly, a week ago, Qualcomm announced that they have now closed that transaction. So it has gone ahead. So maybe a good candidate for a study about whether that should have been notified and clear or prohibited or maybe been subject to commitments. The other one was EEX Nasdaq Power, which was abandoned. So, and I'm not aware of any plans by the parties to go ahead. And then the last one was Microsoft Inflection, which was referred, this famous how do we call them? Equihire, which was referred and then withdrawn further to the Illumina judgment. Again, a good candidate for an economic study because Microsoft did go ahead and hired those people. So I would really advocate for some economic evidence so that we could all be a bit more reassured about the purpose of those call-in powers. However, what I find troubling is that it seems to me that this tool is not only meant to capture those transactions, but it's meant to also capture any sort of transaction where the thresholds are for which the thresholds are too high. And that I do find concerning because, again, and I don't want to repeat everything which was said, but taking a step back, what we're talking about, if it is to unwind a transaction that has been closed, I mean, money has been transferred, employees have been transferred, property has been transferred, stock prices have changed. It's a massive, massive intervention into private property. If an administrative authority can intervene ex post and unwind this transaction. And if we compare it to the US, where such call-in powers exist, at least they have to go in front of a court and litigate. So it's, to my mind, a very extreme measure. And so I would, again, advocate for some concrete evidence that that's necessary, that the cost and the potential, the intervention is justified by some upside. Because, and France is a good example where there's a sector, retail sector, for which lower thresholds were introduced in recognition of the fact that targets often have lower thresholds. So why not? If there's a specific sector for which there is a need for lower thresholds, then I think that could be done in a traditional way. So my advocacy to justify that intervention a bit more. On the French proposal that's on the table, I'll keep this brief because a lot has been said. I did actually read not all, but most of the contributions that were submitted in response to the consultation. And I don't think there was enthusiasm across the board. So I think it's question of interpretation, which option was the least, enthusiasm. But I think there was, and we discussed it with among the community, there was a sense that it was going to come anyway, this calling in power. So most of the comments really focus on damage control, I would say. And so, repeating what has been said, but I do think the local nexus is key, because if we are in a world where every member state can randomly call in transactions that have no nexus whatsoever to their to their jurisdiction, I don't know how that is compatible with what we're trying to achieve, which is a more cohesive market, attract more investment. I just don't think that's the direction we want to go into, especially in the world we live in. But I do think there is a real desire from the business community that there is a local nexus, a clear local nexus, either in by way of thresholds, revenue thresholds, or at least some specific evidence that there is actually there's a specific plan that target will, in the short term, start business in France. So my cry to Nicola is to really make that part of the call-in power. And then lastly, and this is not a French specific topic, but I do think there's a real risk that this is harmful to innovation. And I'm actually surprised nobody has mentioned Draghi yet, because at every conference I've been to, someone has said it. So I'll say it. I'll be first. One of the things that were clearly identified as a problem, a European problem, is lack of financial resources, investment. We like it or not, we need foreign investments. And if you look at if you look at successful European tech companies, startups, Mistral is a good example, it's French, they all depend on money from US big tech. And we can't ignore that, and we can't live in a world where we think that that's not relevant and that we can in the abstract in some vacuum produce our own know-how and we don't need foreign investment. We do. And so I think we need to be careful about tools that really, in my mind, risk at discouraging investment that is needed for innovation to not fall further behind. And so I think that should be really part of the debate. And I stop here.
Thank you very much. Again, very interesting. In particular, your last point, probably. Last but not least, Morissette.
Well, thank you. I'm now just debating a little bit what I can add after so many speakers. Um, as you said, so for us also in the Netherlands, there's not yet a call-in power. There are not yet call-in powers for the Dutch Competition Authority. Friso Kool just introduced the fact that there is a draft bill now pending in Parliament. And what is interesting, actually, and I was a little bit surprised there too, because what he presented as the view of the Dutch Competition Authority is very different, actually, from the current bill that's now pending in Parliament. So the legislator apparently didn't listen very well to the Dutch Competition Authority because in the current bill that's now pending and that would introduce the call-in powers for the Dutch Competition Authority, there are no thresholds at all. It's a very, very broad call-in power. So without that asymmetric thresholds that the ACM suggested, and it's also not combined with the increase of the current uh, turnover thresholds. So the issue of having a lot of filings that are very simple and that take up a lot of the resources of the Dutch Competition Authority, and that they want to use these resources more efficiently, is actually not solved with the current proposal. Nevertheless, there was a public consultation, and I think in general there were 11 views submitted. In general, we felt that the overall view of the Dutch legal community was not so much opposed towards a call-in power itself. It's just that the way it was now drafted in the current bill, that would lead to much uncertainty, legal uncertainty, as was discussed already, I think, at length. Um, and perhaps before I just point to two specific things for that draft bill, I thought it would perhaps also relevant to make that general remark and very much also like in addition to the point that you already made, because the view that was submitted on behalf of the Dutch Association of Competition Lawyers was to make this general remark and encourage the legislator in the Netherlands to look at the European level. Because, as you already mentioned, companies that are willing to invest in Europe are extremely important and are now confronted with national call-in powers in all jurisdictions, but also the uncertainty of 101 and 102 investigations, where every jurisdiction takes a different approach, a different policy, and also the combination of call-in powers and 101 and 102. So this implies for us as practitioners not to make our simple multi-J anymore, but look for every member state whether there is either a regime of call-in, whether the National Competition Authority is very active in using alternatives measures 101, 102, whether there's a local nexus. And that means that even for fairly small transactions, because even for small transactions, very quickly there will be somehow an international cross-border aspect, especially if you're active in Europe. I mean, that's the entire idea of Europe, is making use of the internal market. So once you do that, it means that when you are entering into a potential transaction, very quickly, also for very small companies, you need to make this very burdensome assessment of assessing member state by member state what would be the situation, whether there's a risk of potential calling, and how you want to take steps, whether you proactively approach the authority or not, do nothing, etc. And then there's not only the sort of patchwork of the different merger control regimes, there's also the patchwork of different FDI regimes that we have. So, in addition to that, we have multiple assessments to make, which makes it all very, very complex for companies. And so, our position as the competition from the as Dutch Association of Competition Lawyers was to actually encourage the legislator to also take that European approach and look perhaps much more at a try to harmonize on the European level, whether there could be more coordination between the national competition authorities or perhaps even a shift towards a European call-in power. Because at the end of the day, and I think that's exactly what you said, is if we have this patchwork of different regimes, ultimately this will negatively affect the investment climate in Europe and ultimately also impact our common goal of increasing the competitiveness of Europe. Now, back to the Dutch draft bill. As I said, that's much broader than it was actually introduced earlier by Friso. Um, and as I said, the current draft provides the ACM the ability to call in any and every transaction. And as I think previous speakers on these panels also explained, that that is very different from the other member states where there's typically either a lower turnover threshold, a market share threshold, or perhaps even a specific sector focus to sort of provide a little bit more clarity and also certainty on what the competition authority is looking for. So I think for us, it's very important that in the Netherlands, in line also with what the ACM has envisaged for itself, that the call-in power, the Dutch call-in power should be revised and should also contain somehow a threshold, whether we would believe that probably a low turnover threshold is easiest, but there should be something possibly also the combination with a sector focus, which would very well also fit with the wish for the Dutch Competition Authority to also have now the new competition tool and do much more sector inquiries. So that could be combined. A second element that adds to the legal uncertainty is the fact that there's no clear guidance on what the call-in power means for potential investigations under 101 and 102. And strangely enough, there's also a draft bill pending now in Parliament in the Netherlands that would remove the current limitations that the Dutch equivalent of abuse of dominance has to use the abuse of dominance prohibition to assess concentrations. So currently in the Netherlands, it's not possible to do the tower cast. They can do it, but they use 102, not the Dutch equivalent, because that's not possible. But the draft bill that's now discussed in Parliament is to remove that limitation that's currently in the Dutch Competition Act, which is odd because we believe that it's one of the two. Either you have a call-in power and you use that for the review of possible transactions, and then if you have that, you could not at the same time also arbitrarily look at 101 and 102 as possible solutions. Maybe as a final point, because I'm also very curious whether we still have a little bit of time for debate. When I listened to the debate this afternoon, it also crossed my mind whether we could perhaps make use of what we already have a little bit better. And I thought about maybe looking at whether it's asymmetric thresholds or whether it's different type of thresholds, but being a bit more creative with the current tools that are already there. And to add to that, I thought of the example that the Dutch Competition Authority has introduced in the beginning of this year. So since January, when we submit a filing with with the Dutch Competition Authority, this had to be combined with a case team allocation request form. That is nothing new because you also have that at the European level. But in the Netherlands now, you also need to list the type of transactions that you have done in the past 5 years. So you can only imagine that that not only impacts the transaction that's actually filed, but also potential other transactions. And I thought that already gives the Dutch Competition Authority an ability to look at build, buy, and build strategies. I'll leave it at that. And thank you very much.
Thank you. Alberto, Alberto, I don't know if we have the time for a couple of remarks or questions. Any question? Remarks? Leni. Forse è meglio velare.
Perfect. No, I just wanted to have first a remark and then maybe some consideration. We've been discussing a lot about the legal uncertainty and the difficulty to deal with the procedures that we've got in relation to the below the thresholds, because we don't know whether the authority will act or not. Actually, as some of you have mentioned, the CMA has a voluntary system. It's based mostly on market share. Very difficult. It's not market share, it's share of supply. So it's a bit more complex, actually. The concept of what is an enterprise or part of an enterprise is more complex than the EU law. But I've never heard, we've heard many things about the CMA, but not that the system as it is, it's been like this for 30 years, is unsustainable for the enterprise, for the companies, and create too much uncertainties. But it has a different view. It's really focused on the substance, and you've got a possibility to ask for a non-issue letter to a unit, which is very efficient. It's not always 5 days. They may ask a lot of questions, but they are very efficient, and they are also very efficient not only in dealing with. It's true in a very informal way about questions from the companies and whether they need to notify or not, so that normally in a couple of months you are done if there is a transaction without any problem, maybe even 30 days and maybe even less than that. But they have also a unit which is very performant in detecting the deals that are not notified. I mean, they've got many officials looking at that, which means that also you are not, waiting too much about, maybe I will be able to go under the radar, because you know that there is a very high risk that you will be caught. So there is a kind of incentive for you to be open and transparent. First, because you've got quick answer. Secondly, because you can be detected. So it's a very different system, but I think which calls about when you go below the thresholds, shouldn't we have a system which is unformalistic? We go, I think, too much about, let's do a kind of form CO, or let's ask for a lot of information. Maybe we could have from the national authority something which is more like a quick helicopter view about the essential issue, because I think we know where we're going to go, and not spend months about, request for information as if we were already in a pre-notification, so that we end up with two pre-notification phase. And maybe there is a possibility to be, in that case, if you answer, I think, very quickly to the companies and very efficiently, maybe more companies will approach you, and we will be able to have a better dialogue in terms of the end result. Another remark, and very quickly on that, is I think the problem that we've got in most of our system and also the EU system is that we did not take the UK system. We didn't focus on the substance because we saw that the market share was a problem. Spain was different. We focused on turnover thresholds, most of our system, requiring notification that we know are completely useless, not joint ventures in Japan that needs to be notified in Brussels. And we've got many, above the thresholds, completely uninteresting, but you have to file. But you've got this system very, formalistic. And we are now understanding that this system is not optimal, that there are many things under the thresholds or not caught. And instead of rethinking completely the system and looking maybe at some alternative like the Spanish system or the UK system, what we are doing is just adding and adding and adding. And that is becoming the problem, because it's too much. We go for something which is substance oriented, and we just let it go when it comes to useless things that we are requiring the authorities, the companies to notify. But then we will focus on the substance together, or we go for the formalistic approach. But then the companies that notify on and on complex dealers, which no impact on the market, should be free of having full certainty. At the moment, what we are getting is the worst of the two worlds. It's a kind of substance approach, which is undefined, but still the formalistic approach under the thresholds. And I think that's the problem. And what we are hearing is just a community of lawyers are making maybe a lot of money out of it, but I mean, saying that their company is just saying it's too much. And we need to find a solution to that.
Thank you very much, Denis. Alberto, other remarks or okay. Yes. Thank you very much. I think that we are in time. Thank you. No, no. Questo è tutto. Forse sì, direi, no?
Oh, a very interesting discussion. I both in the first and second panel. I think probably Daniela, you could try to find a good place where to sit where you want to. The both in the first and in the second panel, obviously, in a sense, we are saying the same thing that Denise was saying. There is a lot of uncertainty with this system. I must say, having worked on the discussion when the first merger control regulation was discussed, there were a lot of options which were on the table. And one option was market share. And then everybody said, well, how do we know what the market shares are? How do we find it? Well, the Spaniards have been doing with it. So, but at the time it was thought that it was good to have a clearly defined threshold through which. Now, I think that what we've been discussing today shows that it was not such confusing what it was meant, what below threshold merger control aimed initially to do. It was trying to consider that in certain sectors, in certain areas, there is a lot of dynamism, and this dynamism affects competition already from the beginning of a company or a research or the result of a research. The fact that you have 100 value or of a no turnover company is probably maybe depending on the buyer have an effect on the market, on the process and so on. The problem seems to me that the thing has been complicated over time, and then it's what I found very interesting, I must say, and other issues have come out. Now, what I found very interesting was the German presentation because it puts together the instrument of merger control or the new competition tool that is another issue of which we have been talking and will be talking probably in the future, because it try the ways in which the system is structured is such that we try to find through the value threshold those cases in which there is a risk coming from killer acquisitions. And on the other hand, if we think that a certain sector affecting only local markets or national markets maybe competition may threaten, then I make a market inquiry, and in such a case, I may use my merger powers. I think it's very reasonable because it compels the authority to clarify what are the areas in which it thinks appropriate to use the instrument, which at the end of the story is more or less what more or less we've been saying all along in these panels. Aside other important issues like the local nexus and all the other stuff. Daniele, thank you very much for being with us. We have heard the authorities, you have heard the practitioners, and now let you tell us the view from the Commission and from your speech. Thank you.
Thanks a lot, Alberto, and thanks to all the speakers for the panels that came before. It's an honor and a burden to try to give a bit of a summary together with the Commission view of what we heard today. But I think if I can give it a shot in a nutshell, essentially we are in a situation where Illumina has happened, and the situation post Illumina is that we know for sure that every national competition authority can apply Article 102. It is a fact that some competition authorities are exploring Article 101 as well. Others have call-in systems. Other competition authorities are considering whether to introduce a call-in system. And let's never forget, little Luxembourg can still use Article 22 in the way that the Commission originally envisaged. So how to make sense of this situation? I think the fact that we are in Florence gives me a chance to go back to where this all started. I mean, not the debate on killer acquisition, but this policy shift that the Commission triggered and apparently broke something. So now we have to own all these broken pieces. Was here in Florence. I don't know if you remember it. If you read the General Court judgment, there were many references to the EVP Vestea speech here in Florence 5 years ago in 2020. It was at the IBA. Not far from here, where she said, I mean, we agree that there's a problem. There is an enforcement gap. There had been a discussion at the Commission, should we change our own threshold? Should we legislate? Should we do something? And some of the considerations that she raised were, let's not do a system that is creating too much burden. So let's not set thresholds so low that you have to notify an incredibly large number of deals to the Commission. A system that is flexible, that is proportionate, and that only creates enforcement on the deals where really we are in the phase of a killer acquisition situation. I think that if you think for a moment, and I'm not trying to relitigate the judgment, but also to give you a bit the mindset on the regulator side, what happened during the short life of the Article 22 guidelines is that the Commission took 3 cases. 3 cases out of, I can tell you behind the scenes, we had at least requests for information in, I think, some 80 cases, less than 100 cases over 4 years. And we, in the end, took jurisdiction only on 3 cases, of which only in 2 of them, the Commission sent a letter to member states soliciting the referral. In the third, EEX Nasdaq, I put it in a different basket because it was the competition authorities that came of their own volition to the Commission. So the Commission was not really trying to get the deal. And to frame the discussion a little bit into what are the concerns in terms of legal certainty that this debate has created, there was this line of the Advocate General that the Commission interpretation in the Illumina case, that the Commission's interpretation would have given it powers to review any deal, anywhere, all at once. But if you think of the actual use of this, I mean, it didn't happen in a void. It happened in a situation where you had certain mechanism that constrain the use of this power. So you had to have nexus with the territorial member state, impact on trade, and the deal had to threaten to significantly affect competition. So that's why the selection of cases has been relatively limited. And could a lawyer on the other side of those deals have guessed that the Commission may be interested in these deals? If you see what happened in the same 2 deals that the Commission solicited, so Illumina Grail and Qualcomm Autotalks, to the other side of the Atlantic, to US authorities had a second request in both cases. In one case, they tried to litigate a prohibition, and in the other case, the abandonment statement of Qualcomm on Autotalks the first time that they tried the deal also quoted expressly the action of US authorities. So, I would guess that if you are a lawyer and, you realize that these cases may have triggered the attention of regulators of the US and similarly of the European Union. EEX Nasdaq, we didn't ask for it. It came to us. It was in many instances a merger to monopoly. So what the Commission was trying to address when there was that speech 5 years ago was not any deal, anywhere, absolute powers. We're talking about very few deals with very specific features, which if you try hard enough, you could have guessed that they could have raised the attention of a regulator. It doesn't matter for the law. The law then, has to be applicable in all cases. So, but I think it should reassure you of the intention that the Commission had and still has when it tries to fix these problems in the current debate. So what happened next? I think the judgment in Illumina is interesting for me in the context of the present debate for 2 reasons. One is that you never expect it from your friends, let me call it this way, the phenomenon. When I was studying EU law 15 well, no, 25 years ago, 15 years ago. Well, basically, in my book, it said that there were a couple of courts around Europe that had a problem with supremacy. So sometimes they would come with some odd judgment on supremacy of EU law. One was the tax court in Germany, and the other one was the Conseil d'État in France. I think the first judicial act of the Illumina saga, many people have forgotten, but was not in Luxembourg, was in Paris, where the companies went to the Conseil d'État, which was one of these courts that has historically had some problem with supremacy of EU law. And they said the French competition authority cannot refer this deal to the commission. And the Conseil d'État, in a very short judgment, as is their style, said, well, this is a matter of EU law. Ironically, the Court of Justice responded, no, actually, this time this is a matter for national law, which I found ironic. And the other element which I wanted to quote in this context, also from the judicial saga, was from the actual hearing, the oral hearing in Luxembourg before before the Grand Chamber of the Court of Justice, where the representative of the French Republic after this saga in national court was defending the right of France to initiate a referral, among others, with the argument that all member states are equal under EU law. So if it's a right that exists under EU law, Luxembourg has the same rights of the Republic of France. And the judge rapporteur interrupted him and said, but if you want these powers, why don't you legislate to get these powers in France? And that's actually what's happening right now. So it shouldn't be a surprise that this is what we are witnessing. And I think that the situation currently is that not only France is having this debate, but many other member states have legislated or are in the process of legislating to have powers to try to address these situations. Now, this means that there is a common understanding that there was a problem of killer acquisitions, as they're called, or below threshold mergers, which is the more appropriate technical term that needs to be addressed. Every member state is now trying to find the adequate balance when they devise the solution. In my view, what this has created, if I can make a distinction before I explain a bit what is the Commission position in this context at the moment, is that we have two types of below threshold mergers. One of them is the cases which were the problem cases in our original concept of a killer acquisition, the one that Executive Vice President Vesteia was talking about when she spoke in Florence. So the deals that the Commission may be interested because they are killer acquisitions that threaten to affect competition, etc. The second one is other deals that fall under national control regimes, under these new rules that member states approve under their own national law criteria. And I'm sorry to disappoint you, but on the latter, I think the balance has to be set by national legislators. That's, something that really is of no concern under the EUMR. So this is something that the Commission has no power to intervene on because it's a matter of national law. These are deals that, except some extraordinary situation that you can think about if you are particularly creative, will not really be a matter for EU law intervention. So in a sense, the fact that member states are taking the initiative and it's not an initiative that is taken at EU level means that, the cat is out of the box already. So I think that is something that does not really concern the EUMR, the EU merger regulation. Whereas on the latter, these are the type of cases where the Commission may be interested in what happens on these cases because these are now going to define the boundaries of the Commission's own jurisdiction indirectly. Why? Because the Commission, you may be familiar with it, has announced that it intends to continue its action on killer acquisition, which remained the priority for the current Commission. I think Matteo Beretta quoted EVP Ribera, naming it, calling it one of the main problems that she will have to address in the course of her mandate. And the way that the Commission has chosen to act is basically by relying on the national control regimes, on these national initiatives that are taking place in some member states in its assessment of killer acquisitions. Now, does it mean that we are back to square one? I do not think so. I think what I said before about the type of cases that we were trying to reach when we were considering a reform, well, a new approach to Article 22 that could trigger our jurisdiction on certain cases, means that in all these years we have done a number of initiatives internally to try to monitor these types of deals, and we have also gained some expertise in deciding which type of cases are more likely to raise a problem. And some of these were I do not know if you remember when we had the guidance published on Article 22. This guidance had procedural criteria on how to act based on this new approach to Article 22, which is also why the guidance is no longer in place, because it referred to a legal situation which the court has considered not to be valid. But there were also some substantive indications of what type of deal. There was an attempt to define in what economic sector, what type of deals would be suitable as candidate for such a referral process under Article 22 in the revised approach. I think those indications can still be a useful guidance for economic operators to understand what type of deals are such that they could trigger the attention of the Commission, so that the Commission could still today solicit a referral from a national competition authority to the European Commission. And what does the Commission think of these different systems that are being considered in member states? I think that generally speaking, I mean, the Commission itself does not have a view, but DG Competition considers these changes positive for two reasons. One, because they advance the policy objective of addressing killer acquisitions by defining indirectly a range of jurisdiction for the Commission in case member states were to refer these cases. And the second is because they are, in our view, a better alternative to the tower cast type of situation. The courts also said that when you're faced with a concentration, an ex ante system is preferable to an ex post system. So to the extent that member states define criteria for their possibility to intervene in a deal ex ante, this could offer more legal certainty than a less time constrained and a longer or more uncertain in some cases, even if more limited possibility to reviewing those deals under Article 102. So in a sense, this can advance legal certainty in a sense. The alternative of the Commission of legislating is not an option that we retained so far for two reasons. One is that essentially what we heard today means that there is a lot of ferment at national level to try to define new national systems that can capture these deals. Some of these deals will be interesting for the Commission and they can be addressed through referrals. So is it necessary at this stage, while this is being developed, that we intervene at the European level? At this stage, we have concluded that it is not the best way to go. Member states are taking the initiative in ways that are more consistent with their national legal system. And to the extent that their national legal systems capture deals that the Commission may be interested in, or that may be reviewed in a one-stop shop by the Commission because they're capable of being reviewed in multiple member states, then the Commission can make use of the referral system. So our approach is to see how these legislative initiatives evolve, what they bring in terms of capability to address these regimes, and then continue to enforce on killer acquisitions potentially through a referral system rather than a legislative change. Also because, and this is also a bit ironic, when you think of the alternative approach that is happening next door, and this is me speaking in a personal capacity, but when you go to conferences about merger control, you hear a lot about you should establish thresholds. If you want to have more deals, you should lower your thresholds. Whereas FSR, basically, we are hearing you should abolish these thresholds. You should go ex officio on the cases that deserve to be assessed, because in that system we have the opposite. We have a potentially low thresholds of acquisition on the value of the activities of the target, and then what we get is a lot of notifications. And the complaint there is that creates a lot of burden for companies to be able to notify all these deals to the Commission. So this is not the legislating on this issue at the EU level does not appear the way to go for this reason, for the ferment that there is at member states level, but also because I heard before among the suggestions, creating a call-in system at EU level. Well, if you think about it, I mean, it's not impossible. You could conceive of legislative change that could introduce that, but as such, the merger regulation has threshold, which also in the case law of the Court of Justice are important not only to give legal certainty to economic operators, that's the perspective of companies, and that's a very important rule. But it's also a boundary between what the EU legislature can do and national jurisdictions can do. Because in the enforcement of merger control and merger rules, we're not in a system like Article 101 and 102, where it's the same set of laws that are applied by different authorities in a network. Here we have EU law and national law, and the boundary are certain thresholds that are defined by EU law. And I am not sure that, relieving by an act of the Commission a member state of the power of applying their law in such a system is such an easy thing to conceive, or on which we could get the unanimity of member states. This is speculation at this stage, but it's also something that may not be feasible. In terms of where that brings us in terms of legal certainty, you would have to consider what we've heard in the first panel today as an attempt by member states that have legislated on this matter, or member states that are considering legislation, to do this not in an arbitrary fashion, but to try to identify certain criteria, which we've heard can be market share criteria, can be turnover threshold criteria, or other criteria that still create some boundary that can be that can offer some guidance to economic operators of what type of deals are susceptible of being called in by national competition authority. And at the same time, it gives us the practice that we will have to observe at this member states level may over time offer some of these national competition authorities the opportunity to themselves offer some guidance on what types of deal have proven to be suitable for these calling systems. That is why I think we have to observe this system as it evolves. But at the same time, when we talk about legal certainty, I liked a lot what Saverio said before. I mean, in the end, if a company wants legal certainty, there are certain mechanisms that if a deal is capable of being reviewed in more than 3 member states, and as these systems multiply, it's going to be the chance for more cases. There is a way to ask the Commission to review that deal at the EU level, and if the member states do not object to that shift of jurisdiction, essentially the deal can be notified in Brussels and have legal certainty. Is this unprecedented, what's happening at member states level? As I say, often all I've learned about EU law and competition law, I learned it in the UK before the UK left the European Union. And this is one of those things that has happened before with the UK regime. Because when they were still a member state of the European Union, they had a system under which you had a voluntary mechanism to notify a deal, or they could have some certain investigations under certain circumstances ex officio. And we did apply certain referral rules to that system with a jurisdiction that was not a mandatory jurisdiction. So this is not unprecedented. It's something that's happened in the past. As you all know, it is also res litigiosa, so it's the NVIDIA RNAi case is currently pending before the Court of Justice. So potentially we will also have another intervention of the Court of Justice telling us a bit how to reconcile these different systems that are being enacted at national level with the Commission's own referral systems. And there's another case that has not been quoted today yet that is pending in Luxembourg that still concerns the referral system, and is the Brasserie Nationale case, which brings me back to the example I made before on Little Luxembourg that still can use Article 22 in the way that the Commission has envisioned when it applied the new guidance. Because there is currently a case pending, it's now been re-notified at the European Commission that originates from a referral under Article 22 of the Luxembourgish Authority, which, allow me an aparte, makes me also a bit skeptical that an argument of the Commission was, if it's so destructive, this fact that they refer a case over which they do not have national jurisdiction, why can Luxembourg do something that is so disruptive? It triggers a lot of other questions. All the cases that the Commission took in the past, if you think about Illumina, could the Commission today still accept a referral if it came from Luxembourg rather than coming from France. So those are open questions that well, no, these are no longer open questions. France can no longer refer, but Luxembourg, it's obvious that it can refer these cases. So where do I conclude? I think that a lot of the perception of I would like to conclude on two concepts which are about the specificity of the systems under each national legislation, and about cooperation between the Commission and national competition authority. So on the specificity, it is true that a lot of the perception of this regulatory jungle that applies to certain deals which are broader than national, so there can be global deals that do not hit thresholds, can come from the fact that we have now a multiplicity of systems at the national level, which can have different triggering criteria, different anchor point, different proxies for determining whether there is a local nexus with that member states. And that creates a multiplicity of regimes, which can make it more difficult to assess the system. However, that is not unlike what happens for deals that hit the thresholds. Every member state defines their own jurisdiction in a different way, some by reference to market share, some by reference to turnover. And so there is already a certain multiplicity of systems, even for deals that hit the thresholds at national level. However, what is useful and why these debates are useful is because for those member states that are considering to introduce a system of calling powers, it is important that they hear the experience of other jurisdictions, and they will hear this experience over time in a way that if there are best practices in certain jurisdictions, they can become shared best practices. Hopefully this will happen over time, because now we have some member states that are already taking the first cases under the calling system. We have a discussion among enforcers about about the functioning of these systems concretely, and how they are achieving their stated objectives, what issues there are of coordination between those systems and the application of referral rules to the Commission, so that it's an open debate that can have a positive influence on legislative debates happening in other member states. Which means that on this specificity, the suggestion that we have is it can be useful to be constructive in those member states where these debates are taking place, because shaping the systems based also on best practices of other member states is something that can help overall have more coherence even across member states boundaries. And what I said about the Commission and national competition authorities, and it's my final point, is that cooperation is key. The cooperation is key, and member states are not they have been characterized in some conferences where I've been during the Illumina saga as, the Commission calls and the national competition authorities respond. That's not what happens. And also, again, this is something behind the scenes, but there have been cases, some of which we've seen, on which we asserted jurisdiction, where there were some national competition authorities that decided that they would not send us the case because they considered that there was not sufficient local nexus with their own jurisdiction. In some jurisdiction, we have heard this today on the panel, the national courts are particularly active in checking whether there is a local nexus, or particularly restrictive when they assess whether the local nexus exists with the national competition authority. So we do not operate in a void where the national competition authority, instead of the Commission, now can take any deal anywhere under any circumstances. There are limits under national legislations, as there were limits in the as there are still limits under the EU merger regulation for the Commission to accept a referral. So in this dialogue between the Commission and national competition authorities lies also part of the solution potentially to the substantive problem of killer acquisitions, which I hope is what we all agree is a gap that also the enforcement of the Commission on the Illumina case has demonstrated to be real. It was a case where the Commission showed that there could be significant competitive harm that could come from a transaction that did not hit the thresholds, and where, after having attempted to find a solution at the EU level to cover that gap, the solution is coming from the national level, and that's something that the Commission is observing and at this stage encouraging. I don't know if there is any question.
and how useful has been this conference in a sense, because it answered a little bit your request of uh, comparison, discussion, coordination. Coordination, we don't have it, but I mean, the first two things, I think they are. Now, you have very, very much clarified what is the interest of the Commission and from which the first part of the below threshold merger control originates, and that's we are all agree about. The problem is the other part, in a sense, which is in the domain, as you say, of the uh, uh, of the states, for the national jurisdictions. Personally, I feel that there is also a more general Commission interest in the proper working of the capital markets and of, in this case, of the merger operations. I mean, if they are very costly, Andrea was making examples of what are the effects of a risk of very pervasive, threshold merger control and with operations, with mergers which affect many countries. Then you have costs, and that's not even if we, the practitioners, are the one who see the other part of the cost. They are revenues for us, but they are not probably at the level of the working of the economic mechanism, such a good idea. So I think that the Commission should look into this, even if just in terms of trying to allow a cooperation and some form of standardization of conduct and definition of criteria, which may allow the process at national level and international level more efficient and more predictable, which also is a requirement which the Court of Justice has told us in Illumina. Okay, so I thank you. I thank you very much, the participants in the panels. I thank Mr. For Daniele for this presentation, and I'll see you, many of you probably tomorrow morning at 9 o'clock at the opening of the conference. Thank you.